ready, since we were reading our outlines for the first time.
Well, I'm not going to say anything.
Your Honor, may I approach?
You certainly may.
Good morning, Judge Stafford, Judge McGee, Judge Usman. May it please the court, my name is Andrew Horvath. I'm here for the plaintiff appellant, Dianne Hamilton, who is the conservator on behalf of the ward of the Shelby County Probate Court, Cassie McGill. At this time, Your Honors, I'd like to request 3 minutes for rebuttal.
All right, sir. You may proceed.
Thank you, Your Honor. As the old adage states, bad facts make bad law, which is why we're here today, Your Honor, to seek this court's reversal of the trial court's rulings at the motion to dismiss stage and summary judgment stage to prevent the unusual and bad facts in this case from creating bad law, both for Ms. McGill, our client, and for the citizens of the state of Tennessee. Specifically, the plaintiff seeks this court's ruling that the trial court erred in 3 fundamental ways. By finding that one of plaintiff's factual alternate theories of liability constituted a separate, independent legal claim, which by itself is subject to claim preclusion. By finding that the plaintiff's voluntary non-suit converted the trial court's interlocutory order dismissing that claim into a final appealable order, and finding that the conservator, our client, Ms. Hamilton, when she was appointed, was specifically granted the enumerated power to affirmatively settle Ms. McGill's claims without court approval. Your Honors, this is a medical negligence case that medically is not terribly complicated, but it began in 2011 upon Ms. McGill's admission to the emergency department at Methodist Germantown Hospital. Ultimately, in bringing the case, the plaintiff asserted several theories of liability, all of which, in this case, concern the emergency room physician for whom the appellee Methodist is vicariously liable through a parent agency. Among those theories of liability, one of them was the improper administration of a particular drug called Imitrex. And that Imitrex drug, in and of itself, is so interrelated with the other claims with regard to Ms. McGill's treatment at Methodist that those operative facts, all of those theories of liability, give rise to being but a single legal claim for negligence, in this case, medical negligence. As the Court of Appeals has noted, alternate theories of liability do not constitute separate legal claims. That's set forth in McElhaney versus Hughes. This court also stated in Coleman versus Tennessee Board of Parole, separate causes of action arising out of the same operative facts in one complaint still constitute one single claim. And Your Honor, Judge Stafford, you even authored an opinion called Christus Gardens, in which you noted that different factual theories of liability do not state multiple claims, but one claim. And in this case...
That was for a different purpose, though, wasn't it? Rule 54 certification?
It was, in that case, under the context of whether it could be a final order under Rule 54. Right. Absolutely, Your Honor, but the same analysis applies irrespective of whether we're considering something for Rule 54 appealability issues or for any other thing. If something is a claim, then it is capable of being certified for final judgment status and appealability. If it's not a claim, then it can't be certified for that purpose. And so, Your Honor, what we're saying is that that same exact analysis applies here, where we have a factual theory of liability that the court excised from our complaint based upon an underlying partial directed verdict in the original trial. After we were given that partial directed verdict, we tried to cure our proof. We weren't able to do so based on the trial court's subsequent rulings, so we non-suited. And as far as we are understanding the law in Tennessee, consistent with other jurisdictions, a non-suit, as the Supreme Court has said, brings the parties back to their original positions. And that's not what the trial court ruled in this case. Instead, the trial court ruled that although there was an interlocutory order on that directed verdict, our non-suit against the only remaining party of this one claim concerning Imitrex converted that order into a final appealable order under Rule 3. That's not what the law says, Your Honor. Instead, this very court provided the exact applicable analysis in a case called Frank Rudy Ayers versus Sholaj from 1997, which we cited in our brief at length, where a plaintiff in that case had multiple claims. At trial, there was insufficient proof on one of the claims, and so that claim was dismissed. That was done in an interlocutory ruling. After that dismissal, the plaintiff non-suited, just like we did in this case. And after the fact, upon refiling, the defendant argued that the original dismissed claim was barred by res judicata because that had been converted into a final appealable order from the original case. And this court rejected that argument, finding that the interlocutory order did not address all the claims, rights, and liabilities of the parties, and a voluntary non-suit simply does not convert that into a final order. It is rather merely a part of the proceedings dismissed with no binding effect. That position, that argument, the exact argument being advanced by Methodist in this case, this court found was without merit. And in fact, even if we had attempted to appeal that after the non-suit, the court's order on directed verdict, this court would have properly rejected it as it did in Beal versus Walgreen, which we also cited in our brief, where there was a partial summary judgment granted on a punitive damages claim, which was interlocutory. The plaintiff in that case tried to get appellate review of that issue, even though there were other claims still pending, non-suited the case and sought appeal, and the court rejected it, saying the justiciability doctrine makes this moot. The case has to be alive the entirety of the time. And in that case, if the court was to take it up and review it, it would be ultimately without anything to remand to. It would ultimately arrive at large, instead of it being a specific case where all of the claims, rights, and liabilities of the parties had been addressed. That was not the case there, and that same analysis provides that that was not the case here. Therefore, our position, Your Honors, is that the trial court erred in finding that the non-suit that we subsequently entered after the directed verdict converted that order into a final and appealable order. And lastly, Your Honors, we believe that the trial court committed error by granting summary judgment in this case after the fact. The issue here is whether or not the conservator extinguished by settlement the claims belonging to the ward of the probate court without the probate court's approval as to Dr. Rader, who's the ER physician, the apparent agent of Methodist. In this case, knowing the significance of an individual claim against physicians, we represent physicians as well, just not in professional malpractice capacities, recognizing that significance as a professional courtesy to Dr. Rader after almost a decade of litigation, we extended the olive branch to not sue him in his individual capacity and merely to move against Methodist as under vicarious liability as the principal. And that was accomplished with the entry of, between counsel, a consent agreement that we were not going to sue him before we refiled the lawsuit. After the fact, we receive the motion for summary judgment stating that by doing so, we extinguished the claim against Methodist because it was quote-unquote a settlement with Dr. Rader as the agent. And it simply was not the case, and we knew that to not be the case at the time. First of all,
why is that not a settlement?
It was not a settlement, Your Honor, for several reasons. The first of which was we knew the entire time when we entered into that courtesy, that agreement with Dr. Rader, that in order for it to be enforceable against Ms. McGill as a ward of the probate court, it required the probate court's approval. That's what the court had done with regard to prior defendants when there was a proposed settlement, and we knew that that was not going to be done in this case, and therefore it could not be enforced as against the ward of the court.
Is it required, counsel, or is it optional to have approval by the court?
The statute 343107, which establishes how the probate court grants or reserves rights to a conservator, specifically states that any right that's not expressly or specifically enumerated being granted to the conservator is reserved in the court. So it is permissible for the probate court to grant that power to the conservator if it sees fit in certain circumstances. The question then is, in this case, did that happen? And unequivocally, it did not happen. That's what we knew to be the
Let me
case.
stop you here for just a moment.
Yes, Your Honor.
I understand the position you're taking there. What's the purpose of the agreement then, if you're saying it's unenforceable?
The purpose of it, from our standpoint, was simply to give him a sense of finality before we filed suit again. It was not to bind our client by virtue of that. We knew that would not be the case.
Wasn't he giving up something, though, because he'd asked for discretionary fees and actually had been awarded, what, $13,000 or something in discretionary fees?
He had not been awarded. He had filed his motion, Your Honor.
Stand corrected.
But it's a distinction without a difference, perhaps. Although our position has been that if he had wanted, and we advised the trial court of this, if he had wanted to still pursue it, we would not be able to hide behind that agreement as a shield against having to pay it.
So again, what's the purpose?
There's no legal binding purpose. The purpose of it was a professional courtesy, to give him a sense of finality beforehand, Your Honor.
It sounds like a false sense of finality is being provided.
As to Dr. Rader?
As to Dr. Rader.
I don't believe so, Your Honor, because it was done with the understanding that when we refiled suit, it would have been time barred anyway. And so there's no loss to him with relying on that for a moment. But Dr. Rader isn't even here. It's only Methodist. Methodist is here trying to take the benefit of what they believe Dr. Rader wanted to achieve with that. And it was the same counsel for Dr. Rader as for Methodist the entirety of the case.
So are you agreeing Dr. Rader is now out?
Yes, sir, but he would have been out irrespective of this because of the passage of time. The saving statute would have eclipsed by the time we had refiled suit. And so ultimately, the question here is whether the probate court did in fact give that authority to the conservator, and she explicitly stated that she did not, and that was in the record, and therefore it was error to find otherwise. Thank you, Your Honors.
Thank you.
Morning, Your Honors.
Morning.
Kevin Baskett from the Memphis Bar. Laura Deakins and Will Podesta and I represent Methodist Hospital in this matter. I will cut to the chase and start with the issue that I believe pretermits the Imitrex partial motion to dismiss. The trial court was correct to grant summary judgment, and that is because under Absher, the plaintiff extinguished the claims of vicarious liability against Methodist. The plaintiff entered into a covenant not to sue Dr. Rader. It doesn't matter what it's labeled, what it says at the top, consent agreement. It was a covenant not to sue him. Value was exchanged between the plaintiff and Dr. Rader. The covenant not to sue, the plaintiff released Dr. Rader from liability. Dr. Rader is the alleged agent of Methodist. The only claim against Methodist is through vicarious liability of Dr. Rader. And under Absher, this prohibits the plaintiff from proceeding against the principal on solely vicarious liability claims. In fact, it automatically, once that deal was struck, it automatically extinguished the claims against the vicarious liability claims against Methodist. The plaintiff brought this deal to the table with Dr. Rader. She proposed the deal to Dr. Rader. He accepted the deal. Value was given, and Dr. Rader was released from liability. They then memorialized this in the in the written and signed agreement, the consent agreement. It's found at the record at page 392. It's the consent agreement covenanting not to sue Dr. Rader. There frankly is no real dispute about this sequence of events. Mr. Horvath calls it a professional courtesy. Frankly, I disagree with that because value was exchanged. It's a contract under the base elements of a contract, and it was a settlement that released Dr. Rader from liability, who is the alleged agent. The case law is clear. Absher, Tutton, Johnson, Lavoie, Olympia Child Development case. A settlement with the agent automatically releases the principal when there is only vicarious liability claims being pled. And I submit, Your Honors, that we don't need to look beyond this. The whole argument about whether the conservator had the power to do this or not is not relevant because she did it. Dr. Rader relied on the deal, on the covenant not to sue. They didn't sue him, and that's as far as we need to go. The plaintiff initiated this entire deal. She crafted the agreement, the written consent agreement. She crafted that. She presented it to him. Dr. Rader relied on the agreement. And now, I submit to you, she is relying, she's come up with this argument that she didn't have the power to do it. I submit only because we moved for summary judgment. She now has what I would say, I don't mean to be glib, but it's buyer's remorse because it turned out to not benefit her the way that she thought it would. She would not have raised this probate argument if this had not occurred, if we had not sought summary judgment based on the settlement she entered into, based on extinguishing the claims. Her probate argument, I'll call the advisory opinion that the former probate judge in Memphis wrote, that's her probate argument, and it fails, Your Honors, because the conservatorship order granted the conservator the power to make this deal with Dr. Rader, and the law in Tennessee grants conservators the power to do, the authority to do what they did. Looking at the conservatorship order, it's at the section of it is at record page 185, subsection C. The following rights of the respondent are removed from the respondent, and I'll hit the two that we're dealing with here. Enter into contractual relationships and pursue legal causes of action on behalf of the respondent. That's exactly what the conservator did in this case, the plaintiff did with Dr. Rader. She entered into a contract with Dr. Rader to not sue him, and she elected to not pursue him in this lawsuit, releasing him from liability and automatically extinguishing the claims against Methodist Hospital. Now, the plaintiff has claimed that she had no authority to extinguish this claim. She can't do that without court approval. She can't do it. This is patently incorrect, and we have to look at her actions throughout the course of the original lawsuit before the non-suit and what transpired up to the refiling. Early in the lawsuit, the conservator consented to a partial motion for summary judgment filed by Methodist related to claims of direct negligence against the Methodist nurses and failure to train. So she consented to that dismissal. She consented to the radiologist and his group's summary judgment. She consented to it, extinguished that claim. She non-suited Dr. Rader himself on the eve, the day before we tried the case in the first setting. She non-suited Dr. Rader. She then non-suited the neurologist and his group during that trial. She non-suited Methodist the rest of the case. She non-suited it on the eve of the second trial. And then, and this is key, when it came time to refile, to send out pre-suit notice for the refiling, she did not send out pre-suit notice to the neurologist and his group. She did not sue the neurologist and his group. She extinguished every single one of these claims that I just listed, and she did not seek permission or approval from the probate court or any other court. And yet she stands here and says, I didn't have the authority to extinguish the claim against Dr. Rader, and I submit that she's taken that position because she has to, because she settled with the agent and it extinguished the liability claim, the vicarious liability claims against Methodist. It is contradictory for her to say she couldn't do this with Dr. Rader, yet she did it with 5 or 6 other defendants throughout the course of the litigation. And she did it with the other defendants because she does have the power to do it. She did have the power to do it. She had the authority to do it, granted to her by the conservatorship order. It defies logic that the probate court or any circuit court seeing over a case would have to approve common litigation strategies. That's what she did. She non-suited Dr. Wong, the neurologist, during the trial for some strategic reason. I don't know, but it defies logic that our court procedure would require an attorney and the conservator to go get permission from the court, from the probate court, to make common litigation strategies. We would have had to stop trial so she could go ask the probate court for permission or approval to non-suit the neurologist during trial. Our courts don't work that way. It cannot be the public policy of this state to make a conservator have to approach the attorney, approach the probate court to make decisions like this. Mr. Horvath said bad facts make bad law. That will be bad law. To take the decision, the strategy out of the hands of the conservator and her attorney who she's hired, and go to the probate court or the circuit court or whomever and get permission or approval to make common litigation strategies like she did with Dr. Rader. And that's because court approval is not mandatory. It may be good practice to insulate the conservator after a settlement. It may be good practice, but it is not mandatory. The probate...
Is there a distinction here between the conservator and the conservator's attorneys?
I'm sorry, a distinction between the two?
Between the two?
No.
In other words, do we assume that the conservator was consulted and agreed with whatever course of action the attorneys took?
I think we have to, Your Honor, because...
Nobody's raised that as a concern.
No, but attorneys, they are the agent of their client.
Sometimes.
Sometimes, but nobody has raised that issue, Your Honor.
Okay.
The plaintiff relies almost exclusively on the probate judge's advisory opinion, and we respectfully submit that the advisory opinion is just wrong. The idea that it was mandatory to get court approval defies what the conservator did throughout the course of the litigation with the other defendants, dismissing them when it benefited her strategy to do so. The probate court, frankly, the advisory opinion relied on the wrong law. She took all of the minor settlement mandatory approval, the statute found at 29-34-105 that deals with approval for a minor's settlement. She relied on that, which does have mandatory language. The statute that's at issue is 34-1-121B, and there is nothing in it about court approval or a hearing being mandatory. It says the court in which the action is pending has the power to approve and confirm. It does not say the court shall or the court must. It doesn't say that like the minor's settlement statute does that says the court shall conduct a hearing. If the legislature had intended for court approval of a settlement involving a conservatorship or a disabled person, if they had intended for court approval to be mandatory, the legislature would have written it into the statute. And we know that that's the case because that's how it operates. The legislature is not going to delineate powers to the nth degree. The statute giving conservatorship powers, 34-3-107, lists as an example of many, but not limited to, the power to contract, the power to execute legal documents of legal significance.
Is it appropriate for this court to consider the probate court's advisory at all, or is it simply a nullity?
It is a nullity, Your Honor. It is the law is clear on that. That advisory opinions are frowned upon, if not prohibited in Tennessee. The court, in no shape, form, or fashion, should consider that advisory opinion. And I think the probate judge, candidly, she said in her advisory opinion, this has no effect on my sister court, the circuit court. I have no jurisdiction over there. That advisory opinion should not be considered in any shape, form, or fashion, Your Honor.
And what was the purpose of the advisory opinion? Or the opinion from the probate court, however you want to term it?
I don't know, Your Honor. I'm a little bit like a duck in the desert when it comes to probate actions. I wonder if the former probate judge thought she needed to help because, I mean, candidly, it did. It took the plaintiff's view of this entire thing. I wonder if she needed to help the ward. I don't know. I don't know the purpose of the advisory opinion. The Goodman versus Home Away from Home case, Your Honors, along with 34-1-121B, those are squarely on point. Our trial judge in circuit court, Judge Wagner, she considered the Goodman case and relied on it because it is on point and it is controlling in this case. And that is that settlement by a fiduciary on behalf of a disabled person does not have to be court approved. It is not a requirement. It is simply a discretionary power of the court, whether it's probate or circuit or wherever, because not all the counties, as a matter of fact, very few of the counties in Tennessee have probate courts. So it is the power of the court, not the requirement. And like the Goodman court said, like the Court of Appeals said in Goodman, if it is a bad settlement, then the ward's recourse is against her fiduciary. The recourse is not to void a deal, a bargained for deal that was struck between the conservator and Dr. Rader. That's why we go back to what I said earlier. I submit we can stop the analysis after the deal was struck and Dr. Rader was released from the lawsuit. Because whether or not the conservator, even if the conservator didn't have the power to do it, she did it, and it stops right there. And by operation of law under the Absher requirements, the Lavoie case is very succinct when it says, once the agent is released from liability by virtue of settlement with the plaintiff, the principal is automatically released. That release, the settlement, court approval or not, the settlement with Dr. Rader, the covenant not to sue with Dr. Rader, automatically released Methodist. It extinguished the vicarious liability claims. We submit, Your Honors, that that's as far as it needs to go and that the trial court should be affirmed and summary judgment should stay in place, the order granting summary judgment. Now, we submit that the Imitrex issue is pretermitted by the summary judgment, but I'm going to touch on that in the minute 27 seconds I have here to go. That the directed, let me gather my thoughts here to shorten this down. The directed verdict is a dispositive ruling on the merits. It's like a partial summary judgment. It's very much like a partial summary judgment, but at a different point in the trial. The plaintiff failed to carry her burden of proof at trial on the issue of Imitrex, and directed verdict was granted, and that became the law of the case. The case was mistried, and if we had retried instead of the case being non-suited, it would have been the law of the case then. The plaintiff either had to seek interlocutory appeal at the time that the directed verdict was granted or seek it after the non-suit. And that's because non-suits extinguished the remaining claims and end the lawsuit. Imitrex was not affected by the non-suit because it was already extinguished by virtue of the dispositive ruling. And the non-suit extinguished the rest of the claims. The law in Tennessee is clear. Pages 57 to 59 of our brief, we cited dozens of cases explaining that interlocutory dispositive rulings on the merits, like a summary judgment, partial summary judgment, or an interlocutory or a directed verdict, those become final and appealable after non-suit has extinguished the remaining claims, and that's exactly what happened in this case. I think it's as important. Rule 41 of the civil procedure is what makes the difference because it has the exception. You can't non-suit a case when there is a directed verdict that has been sustained. I'm out of time, Your Honors, and I apologize for going over. We respectfully request that you affirm the trial court in all respects.
All right,
Thank you.
sir. Thank you. I believe you have 3 minutes.
Thank you, Your Honor. May I proceed?
Certainly.
Just to address a few items that were raised by the appellee. The question of whether the conservator had the power is not irrelevant. It is crucial and central to this analysis, Your Honor. The language that they cite in the original order appointing conservator only deals with basic contractual obligations and the initiation of legal claims, not the affirmative extinguishing of those legal claims.
Does the agreement differentiated like that?
The agreement with Dr. Rader, Your Honor?
No, the powers, are the powers differentiated like that?
The powers, as the probate court even subsequently clarified even further, the powers are not, there's no further distinction between those. What the court explained was that she specifically never included language about resolution, settlement, or otherwise affirmatively extinguishing legal claims. And by operation of the statute, 34.3107, anything not specifically granted is reserved. What the trial court did by saying that if the probate court wanted to include that exception, she had to include it by saying this order does not grant that right. That's a complete inversion of the way that the statute operates.
If that were the case, then why was not all these issues that opposing counsel pointed out treated that way? Why didn't you go back to the probate court and make sure you had authority to do whatever you did?
It's a question of how those things were handled. When something was,
I don't understand what you just said.
I'll make the distinction as best as I can, Your Honor.
Okay.
There's the difference between attempting to affirmatively enter into a proposed settlement agreement, call it covenant not to sue or otherwise, as opposed to allowing defendants out of litigation at any given point where it is not permanent or binding because they could always be renamed subsequently.
And where does that distinction come from?
Whether it's affirmative or passive.
No. What's the basis of that distinction? I understand the
Okay.
distinction. I don't understand where it comes from.
I'm not sure that there's any specific.
Can you point to something specific, something statutory or something the probate court, some order that the probate court gave you that
Yes.
gave you that authority?
Well, what I can point to, Your Honor, with the 10 seconds I've got left, is the probate court's order actually approving one of the proposed settlements with a prior defendant. And in that, saying that the court has reviewed it and therefore is going to approve it and it will be enforceable as against the
But
ward.
that was because the probate court was requested to approve it, wasn't it?
It was.
But all these other actions, the probate court was not requested to approve.
Correct.
Okay. All right, thank you, counsel.
Thank you, Your Honor.
Appreciate your argument. We will endeavor to get you an opinion at the earliest possible time.
Appreciate the court's time.
And you may be excused, counsel. Thank you.
Thank you.
Ms. Angie, let's go back to case number 1. Have we heard from anyone?